the response from the courtroom, and there were a lot of scenes at the court. And you see the parliamentary candidates, some of whom were making an appearance at the Supreme Court for the very first time. And so the whole thing was very interesting. Lawyers of the Electoral Commission, led by Justin Amenuvo, also made the EC's position clear to the court. And of course, Gary Nimakun, who represented the NPP side, also advanced. And then for them, their position was that, look, whatever took place at the High Court, the remedy is at the Court of Appeal, not the Supreme Court. But hey, the panel of 5, presided over by Justice Gabriel Puamang, with support from Justice Professor Henrietta Mensah-Bonsu, Justice Ernest Gawu, Justice Henry Anthony Kofi, and Justice Ejie Frimpong. So these 5 justices took the decision. And in fact, do you know what one interesting thing that happened in relation to last Friday? After listening to the parties, and then they retired to go and consider their decision, they came back after 3 hours of waiting, after 3 hours of after hearing, they retired. And when they came back, the decision was handwritten. It was a handwritten decision. That is, so you notice at the point in time when Justice Poma was reading, at the point in time, there was something that he had to wait for a while before he has to clarify that particular point in time. And they say that everything will be typed, everything will be made available at the registry. But of course, we've been talking about all of this. Let's hear from the Supreme Court, really, what the decision in relation to the constituencies in contention is.
Now to our orders. We have taken note of the fact that the applicants did not contend that there had been earlier completed collations in respect of Nsawam Aduajiri and Ahafwano North constituencies per paragraph 8 of the affidavit sworn to by Fifi Fiabikwete dated 16 December in support of the motion for judicial review filed by the applicants on 16 December 2024. Since the orders which have been brought to be quashed are separate and distinct, we have decided to exercise our discretionary power to quash by certiorari, having regard to the peculiar circumstances of each ruling. Consequently, we hereby quash the orders of mandamus made for collation of results by the Electoral Commission in the following constituencies. 1. Okaikwe Central. 2. Ablekuma North. 3. Tema Central. And 4. Techiman South. Accordingly, the collation of results in the above constituencies by the Electoral Commission after 20th December 2024 on the orders of the court are hereby set aside. For the avoidance of doubt, the orders of the High Court made in respect of Nsawam Aduajiri and Ahafwano North are not affected by this order, by this our order, and in effect, those declarations stand.
Okay. Yes, so in effect, 2 out of the 6 are not affected by the orders of the Supreme Court, but 4 have been affected. And in that manner, what it is now is that they have to go back to the High Court. And the court is saying that, look, whatever have been brought to the Supreme Court, the matter in which the court used to give the order still remains. The parties will have to go to the High Court for the High Court to hear them, and then a determination will be made. Remind you, the issue of which the NDC went to the Supreme Court was that their application for joinder to be made a party because they are an interested party was declined, and so they were not given the opportunity by a decision that they are an interested party. And the Supreme Court made certain orders. Let's hear the order. The order include the case being put before a different judge. Let's hear the Supreme Court again.
Despite quashing the orders stated above, The applications for mandamus themselves are still alive and ought to be heard and determined. In line with our conclusion on this application, we exercise our powers under Article 1294 of the 1992 Constitution and make an order pursuant to Order 55, Rule 65, to the effect that the applicants herein are granted leave to file affidavits and statements of case in answer to the respective applications for mandamus, those which have been called as interested parties. The time for filing is hereby abridged to 2 days from today. The applicants for mandamus in the High Court upon service may respond to the processes of the interested parties. Having regard to the circumstance of time constraint on the national electoral calendar, we hereby abridge the time for the hearing of the mandamus applications in the High Court and direct the High Court to hear the applications for mandamus on Tuesday, 31st December 2024. I hope Tuesday is 31st. On the issue of bias, we are not satisfied that sufficient evidence has been provided to us by the applicants. Nevertheless, in order to maintain the integrity of the adjudicatory process and in line with the practice of this court in cases such as Republic versus High Court, ex parte, Ajua Company Limited, Auditor General, Interested Party, 2019-2020 Supreme Court Law Report of Ghana, Adare, we hereby direct that the applications for mandamus that are extant shall be placed before a different High Court judge for hearing and determination.
Yes, so you heard from the Supreme Court. The abridge. So somebody will ask, what's this abridge? So abridging the time means, of course, if the matter is to be heard 2 weeks, they are bringing it forward to like a day or two. So the court uses its own powers. Absolutely. The High Supreme Court supervises all the lower court, and the lower court include the, in fact, the courts are below in that setting that it has today. The Supreme Court. All courts are under the Supreme Court. So exercising its supervisory jurisdiction, the court is saying that we are exercising our discretion to say that the matter at the High Court be heard tomorrow, Tuesday, tomorrow 31st. The whole year. You see a lot of them in church.
Yeah, they'll go to church.
They will go to church. So tomorrow is the last day of 2024, and the court will sit in relation to that. But of course, the Supreme Court, upon all these things that they have said, have a conclusion to the application filed by the NDC. And let's hear the Supreme Court on their conclusion to the application.
To conclude, by the conclusions reached in this decision, reliefs A1, A2, A4, and A5 endorsed on the applicant's motion paper are hereby granted, while reliefs A3 and A6 are refused. Reliefs B and C are hereby dismissed. Ordered accordingly.
So, Lily, you know why sometimes people get confused when you go to court?
But
if you don't,
some of the terms,
absolutely. Reliefs A and B, and what are the reliefs? So if you have not read the processes, if you are not familiar with it, then you are sitting and say, it didn't cry no more.
Yeah.
So the reliefs, the preamble that he gave us earlier, those quash, those did not quash, and all of that. Go to Starr online starfm.com.ga. The whole story is there. All the reliefs have been stated, and just as Justice Gabriel Paman mentioned, you see all the reliefs. So some of the relief that they were seeking, some were granted, and others were dismissed. But of course, in the chamber, for the first time, you have some of the parliamentary candidates, I must say, present in court. Some of them were just watching what was happening when I engaged them earlier, when the court retired and all that. But after the court sitting, we've been interacting with particularly with the NDC parliamentary candidate who were earlier declared winners before the High Court ruling. Let's hear from some of them.
Earlier, I told you that we're optimistic and hopeful that it's going to, the true mandate of the people will still stand. We're grateful to the courts for heeding our request. The law has spoken. Merry Christmas, Happy New Year.
We're happy to go and continue. I think it's important that everybody understands that this is just the beginning of our work. And I think that this experience equips us to be able to represent all our people a lot better. So we're very grateful and for the opportunity. And also we want to say hello to Ghanaians and our constituents. Merry Christmas, Happy New Year.
Well, I think it's a good day for country. The whole world is watching, not just Ghana. So I think it's just the beginning of coming together as one people. And then I think it redeems the image to an extent of our courts and our judges. So it's all well and good. All well and good.
So the voices you heard, the first one was Baba Sadiq.
Okay.
The second one was Ibi Bright.
Bright.
And then the third one is Irabna
Obi. Okay.
Yes, so
okay.
they also were reacting to the decision of the Supreme Court. But what about the front runners, the lawyers who advanced the cases? For the NDC, Edigi Tamaklo was very brief. But his counterpart, Gary Nimakun, has a message for the NDC. He said, we are not enemies, we are friends, but they have to make sure that peace reigns. Let's hear from them.
The only thing I want to say is that we are grateful to the court and nothing else. And Merry Christmas. Merry Christmas.
You saw me hugging them and talking to them. And this year they are not enemies. We are not fighting. It's a question of the brains. We are not fighting. No, not after today's ruling per se. It's peace post-elections. You realize that after these elections, there a lot of post-election violence. We don't understand. There must be peace in the country. If we won elections, what about the destruction of state properties and all these things? It's not good. So let's all learn to abide by rule of law. That is the way I see it. That is all. So please, all parties, political parties, especially our brothers in the NDC, they should learn to respect the law. That is all.
So Gary said, my people in the NDC, please, let's respect the law.
Learn to respect
the law. And all that. So the first voice was Edigi Tamaklo, and then the second one was Gary Nimakun after the court decision. But you note one thing that the panel did after their decision was that they urged on the police, the IGP, look, make sure your men act professionally. They shouldn't go to the centers to ferment troubles, to lead those who come there to engage in some unlawless activities and all that. Then after, the court also took time to advise the political parties to make sure they call their followers to order. So that is one of the reasons you heard Gary making that position and all that. So there were many who were asking that question. Anthony Krakran is saying, whatever the Supreme Court has said, what does it mean? What does it mean? Good. Dr. Justice Shremsai has an explanation to what the decision of the Supreme Court is a moment after the ruling.
6 constituencies that have come to the Supreme Court, 4 of them have been declared null and void. Of course, the court is asking that they have to go back, and then the orders of the court has been nullified. So you can see some party faithful jubilating over there in all of that. So basically the Supreme Court has spoken, and then the parties will have to come back again on the Tuesday, the 1st of December, for a decision to be taken in relation to the mandate. So I have Dr. Justice Shremsai, who has also been at the Supreme Court. Just help us understand what the decision of the Supreme Court is really to the already declared seat. The court is saying that in respect of 4 out of 6, the order has been quashed. What does it mean?
Yes, so you would recall that in the facts, 2 of the constituencies had not yet been declared, and 4 of them were declared. So the court's ruling is that those 4 that were not declared, the order was quashed in respect of them. And what it means is that there is no order for recollation as we described it in the case. And so the court's further direction is that those cases are supposed to continue. And as you can see, the point we have always been making has been that no court really has jurisdiction to refuse to hear a person who is an interested party or who's in respect of whom an order will be affected. So to the extent that the court expressly refused to accept these people, to hear them, is a fundamental flaw in the whole case. And so the court went further to take the case from the judge, basically saying that what you did shouldn't be done, and we want people to have confidence in the judiciary. So even though we are not saying that you have done anything untoward, what we are saying is that we want people to feel that they are being heard, and that is why they moved the case from that judge, and the case will be assigned to a different judge to hear the matter.
So with those parliamentary candidates, those who were affected specifically with the NDC candidate, what should they be thinking right now? Are they winners as had been declared earlier by the EC?
No, as far as our position is concerned, and the position, once the order is quashed, we revert to the status quo ante, which is what used to be before the order of 20th December. So what it means is that they had already been declared. And the argument that the EC had been making that they would redeclare, now that case will be heard on the merits, whether there should be a redeclaration, as we call it, a recollation. Because our position has always been, and that is the point of conflict. While the MPP guys are saying that they don't believe the results could be collated and recollated and the EC can correct its own mistake, we are of the view that once results have been declared, and the EC has been abiding by this principle for some time, and once the result has been declared, the only way you can challenge it is when it's gazetted and then you file a petition. That has been our point. So now I believe that will be the argument before the court, whether or not there should be an order of recollation.
Yes.
So that's Dr.
Justice Stremsai, giving us some education there in relation to all that took place at the Supreme Court. So the Supreme Court, the apex court of the land, has spoken. Tomorrow, it is expected that the parties will appear before the High Court, and in the course of the day, we'll know which specific High Court this matter will be put before, and whether indeed or whether the applicant, that is the parliamentary candidate of the NPP, will be interested to push this further, and what the will be the response from the NDC side and all of that. So hopefully tomorrow we'll bring that to bear. So, and on court today we decided to give you a review of all that. But one of the cases that is coming up is the Samuel Nkum matter. We
talked about a while ago,
So today he's appearing at the circuit court in relation to the $3,500 matter. As for the 4,001, he has to appear on the 17th of January. So that is it. So for those who have those football fans who have our footballers, our ex-footballers at heart, you should be saying a word of prayer. As it stands, it is an allegation. It is alleged. So until proven, then what is still to mean is that he says that he is not guilty. So, but in relation to this matter, we are told, or the court is informed, that he's paid 7,000, and there's a balance of 25,000 that is supposed to be paid. So more on this tomorrow. We'll in our bulletin at 12 midday news. Yes, the 12 midday news will give you an update on all of that. So call today, even though the year is getting, and all of you are chilling out there. We are serving you.
We're still serving you. Yes, this is what we give you. This is our little Bronya gift to you.
So enjoy. Once you are chilling, just sit comfortably and listen to. Lily has more for you.
Absolutely. Thank you, Captain. I'll catch you on the flip side, definitely. Right? So that's Mutala Inusa with court today. We are all rising from the court. Let me take a quick breather. Let me drink some water and obviously make some money. I'll be right back.
Let's have breakfast on the Morning Star. This is Star 103.5 FM. Simply the best.
Wake up, oh. Now we've got places to be. Bronya way there. Me no wow. Me see Bronya sexy. Yebeko Stadium. Share movies. Ako cooking classes. Ako skiing.